Losing a $200,000 home over a debt of $133.88, that is not a hypothetical. It is a real example cited in the legal commentary surrounding this year's biggest tax foreclosure ruling, and it points directly at a second constitutional argument sitting inside Pung versus Isabella County that most coverage of the case skipped entirely. Everyone talked about the takings clause question, whether homeowners are owed fair market value or just the auction price. Almost nobody talked about the second argument the Pung family also made, that seizing a home worth vastly more than the debt owed is not just an improperly calculated taking, it is an excessive fine, banned outright by the Eighth Amendment. The Supreme Court rejected that argument too, and understanding why matters for anyone thinking about how to actually challenge one of these foreclosures going forward. Quick housekeeping. I trace every constitutional argument raised in a case, not just the one that generates the most headlines, because the argument that loses often tells you as much about where the law is headed as the one that wins. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into the argument almost nobody covered. Quick recap of the primary holding, since it sets up why the second argument mattered so much to the Pung family specifically. On June 23, 2026, the Supreme Court ruled 9-0, in an opinion by Chief Justice Roberts, that the takings clause baseline for calculating a tax foreclosure surplus is the price a property fetches at a fairly conducted auction, not an estimate of its fair market value. The Pung family's Michigan home, assessed by the county at $194,400, sold at auction for just over $76,000 after a tax debt of $2,242. Under the takings clause ruling alone, the family's recoverable surplus shrank dramatically, calculated against the lower auction figure rather than the higher assessed value. This is exactly why the second argument mattered so much to their case specifically, and why it is worth understanding on its own terms rather than treating the takings clause ruling as the entire story. The Pung family also argued that the underlying tax forfeiture process itself violated the Eighth Amendment's excessive fines clause, the same constitutional provision that limits punitive financial penalties imposed by the government generally. Their theory was straightforward. Taking a home worth many multiples of the actual tax debt owed functions, in practical effect, as an excessive financial punishment for the underlying offense, however you characterize that offense, being unable to pay a comparatively small tax bill on time. The lower court had already waved this argument off as ordinary tax collection, not a fine at all, and the Supreme Court agreed, rejecting the excessive fines claim as well, on top of ruling against the family on the takings clause question. The court's reasoning here draws a conceptual line that is worth understanding clearly. A fine, in the constitutional sense the Eighth Amendment addresses, is generally understood as a punitive payment imposed as a consequence of violating the law. Property tax collection, even when the ultimate consequence is losing a home worth far more than the debt, is categorized instead as the government recovering money it is legitimately owed. A civil debt collection mechanism rather than a punishment for wrongdoing, even though the practical, felt consequence for the family losing the home looks considerably more punitive than that legal characterization might suggest. Here is the detail that makes this specific rejection worth tracking closely, rather than treating it as fully settled, because it was not a unanimous, uncomplicated dismissal of the argument. Legal commentary following the oral argument specifically noted that Justices Gorsuch and Jackson had flagged the excessive fines theory for real consideration during the case's development, an unusual ideological pairing, generally on opposite ends of this court's overall spectrum, both taking the argument seriously enough to signal interest in it before the final ruling came down. That detail suggests the excessive fines theory, even though it lost in this specific case, retains real intellectual traction with at least some justices, and a future case with a more extreme fact pattern, an even larger gap between the debt owed and the value seized, could plausibly present a stronger vehicle for reviving this exact argument down the road. That is precisely where the example I opened with becomes relevant. A case referenced in commentary surrounding this ruling involving a veteran with dementia in Washington, D.C., who reportedly lost a $200,000 home over a debt of just $133.88. Cases with a gap that extreme, between a genuinely tiny debt and an enormous asset seized to satisfy it, are exactly the kind of fact pattern that could eventually give the excessive fines argument a stronger foothold than the Pung family's own case provided, since $2,242 against a $194,400 home, while still a large ratio, is a meaningfully less extreme gap than $134 against $200,000. Let's talk about what this means practically if you are ever facing a tax foreclosure yourself, or advising someone who is. The takings clause argument, the one Pung actually resolved, is now the more constrained path. Your recoverable surplus is measured against the auction price, not fair market value, following this ruling directly. The excessive fines argument remains technically available as a legal theory since Pung rejected it on this specific record rather than closing the door on it as a category entirely, but it faces a real, demonstrated skepticism from at least 7 of the 9 justices, with only Gorsuch and Jackson showing documented openness to it during this case's development. If you are in a situation where the gap between your actual tax debt and your home's value is extreme, dramatically more extreme than a typical case, this is a legal theory worth raising with an actual attorney specifically, rather than assuming it is foreclosed as an option simply because it lost in Pung, since the court's rejection here was tied to this specific record, not a blanket declaration that no tax forfeiture could ever, under any circumstances, constitute an excessive fine. Step back and look at what this second, less covered argument tells you about the actual state of this entire area of law. Pung did not just answer one narrow question about how to calculate a surplus, it tested 2 genuinely separate constitutional theories in the same case, and rejected both, while leaving a visible, documented crack in the second one, specifically 2 justices on record as taking it seriously, even in defeat. That is a meaningfully different, more complete picture of where homeowner protections in this area actually stand than a summary focused only on the headline takings clause holding would give you, and it is exactly the kind of detail that gets lost when coverage of a major ruling collapses a genuinely 2-track legal argument down into a single, simpler story. If tracing the argument almost nobody covered was useful, hit like so it reaches people trying to understand the full legal picture here, not just the headline result, and subscribe if you have not. Because if a fact pattern extreme enough to genuinely test the excessive fines theory reaches the court again, I will be covering it the moment it does. Tell me in the comments whether you had heard about the 8th Amendment argument in this case before this video, because that tells me how much more of this kind of underneath the headline legal analysis is actually worth building into videos like this one going forward.